Hello and welcome to Personality Crisis. I am Dylan Ris, your host of this episode, and we are very honored to be joined today by Steve Vladek. Steve is a professor of law at Georgetown University Law Center. He is a frequent voice reporting on, commenting on all goings of the Supreme Court, and there's no better time to have him than right now when the court has just wrapped up its term and announced all sorts of decisions. And Steve, I think it's a really great time for America because by a vote of 5-4, the court has announced that they are going to abide by the Constitution, right?
I mean, it could have been 5-4 against the Constitution, so I guess it could always have been worse.
Yeah, that's true. Well, maybe Steve, let's dig right into that. The decision starting with the 5-4, or I guess in some senses 6-3. You can explain to us decision regarding the 14th Amendment's position on birthright citizenship. What should we know about it?
Sure. So this was a challenge to President Trump's day one executive order in which he purported to limit who would be entitled to birthright citizenship and basically said, if you are born to undocumented immigrants or to individuals who are only temporarily in the United States without some kind of permanent immigration status, that you're not entitled to citizenship. The Supreme Court held that that is unlawful. But there was a little bit of wiggle room as to why. So 6 justices all agreed that the executive order violates the relevant statutes that Congress has enacted to protect birthright citizenship. And then 5 also held that even if Congress wanted to change that, it couldn't because the Constitution itself, through the citizenship clause of the 14th Amendment, guarantees birthright citizenship to everyone born on U.S. soil except for, 4 well-recognized and not new exceptions. And so it was 6-3 against Trump. It was 5-4 that even Congress couldn't do this either.
And were you surprised by the final vote tally?
I was. I mean, so a lot of sort of court watchers will wait to handicap until after the oral argument because not always, but often you can get a really, really clear vibe of where the justices are going based on their questions at oral argument. And the questions at the oral argument in this case, back on April 1st, really made it sound like at least 7 of the justices, and perhaps even 8, were hostile to, were skeptical of President Trump's executive order. Now, 7 might not seem like that big of a difference from 6. I'm a lawyer, not a mathematician, but I think I can do that math. But I was surprised in 2 respects, Dylan. I was surprised that Justice Neil Gorsuch, who was one of the skeptical questioners during the oral argument back in April, nevertheless was in the dissent on both of the issues in this case. And I was really surprised by Justice Brett Kavanaugh, who wrote this weird opinion where he says, I totally agree that this executive order is unlawful, that it violates the statutes, but the Constitution is totally different. And Dylan, what's weird about that is the second part was totally gratuitous. Right? Usually, if you agree that the president's actions are unlawful, you don't reach out to say, but in a different world, if something else were to happen, here's what I would think. And I found both of those features of the ruling a little bit surprising.
Can you ascribe any motivation to why maybe specifically those 2 made their decisions? Gorsuch flipping from what his oral argument seemed, and Kavanaugh seeming to go out of his way to extend an olive branch.
Yeah, I mean, so they're very different people, even though they often end up in the same place in these cases. I think, Justice Gorsuch has shown no compunction about voting against President Trump, and so I don't think it was that. He was in the majority back in February in the tariffs ruling, where the court blocked President Trump's reciprocal tariffs. I think he probably just ended up deciding that he didn't find the constitutional arguments persuasive. And he's not one to worry that much about prior Supreme Court precedent. So the fact that the Supreme Court had answered this question in 1898 didn't bother him so much. Kavanaugh is trickier. I think Justice Kavanaugh is much, much more aware of and responsive to his perception of where the public discourse on the right is on many of these issues. And so I think he probably viewed his position as sort of a split the difference view, where he was going to block President Trump from doing this while giving, as you say, an olive branch, right, to this not so long ago fringe theory of constitutional interpretation. I wish I could say that I had seen that coming, but I didn't, because I figured that if you thought the statutes were clear, well, what were the statutes doing? They were implementing the court's interpretation of the Constitution. That's where I think I got Kavanaugh wrong. And I think the larger point, Dylan, is not about me, right? It's about sort of this court, not just in the birthright citizenship case, in lots of other cases. Even when it rules against Trump, it finds very, very narrow ways and narrow majorities to do so, with more justices endorsing legal positions that we would have described as off the wall not that long ago.
As you said about Kavanaugh, he seems to be perceptive of sort of outside opinions, at least in right-leaning legal circles. He and Roberts have more political backgrounds than some of the others on the court, and would you say it's fair to ascribe political triangulation to those two, or to anyone else on the court?
It's interesting, Dylan. I am one who is very critical of the court, but also tries to assume that the justices are always acting in good faith, right? Even when they might not be, because what do we accomplish if the answer is they're not, right? Like I want to try to build the argument that even if the justices were acting in good faith, they're still wrong. And so, yeah, maybe there was some motivation on the part of some of the justices to put wind behind the sails of this very anti-immigration agenda of the Trump administration. We're seeing in the, now first 24 hours since the decision, right-wing media really picking up on that. But also, I think, Dylan, we have justices who have just some pretty outlier views, at least historically, when it comes to what the Constitution means. And, I think it is very easy to get lost in the moment about this court and reading just what the justices write and say, well, that's not crazy. When you put it in the broader context of how we've understood the Constitution for the last 230 years, it's like, oh, actually, that is a little crazy. That's, you can think the justices are acting in good faith and still think that we have a court that has pretty radical views of a number of constitutional provisions that we have not seen on this court before.
Yeah. Well, how do some of those views manifest in some of the other decisions that we received this week? I think let's first perhaps talk about the Slaughter case, where the justices ruled that the president actually has far more latitude to fire members of the federal bureaucracy than had previously been allotted.
Yeah, I mean, I think the Slaughter case is actually probably the biggest decision of the entire term and the most important separation of powers ruling the courts handed down, probably in the 21st century. I mean, it is really hard to overstate just how much of a nuclear bomb it is on the relationship between Congress and the executive branch that the Supreme Court is now saying, and we'll get to the Federal Reserve as why it's an exception, but that for the most part, Congress cannot insulate any executive branch agency, even ones that are supposed to be and need to be independent, from direct, immediate presidential control. So Congress can't insulate the FDA from presidential interference in drug approvals. Congress can't insulate the FCC from presidential interference in merger negotiations and in antitrust litigation. These are radical changes that, one, required the court to overrule a unanimous 91-year-old precedent, but two, Dylan, required the court to embrace whole hog, a theory that, again, was largely viewed as an outlier as recently as 20 years ago. And that all would be bad enough. But at literally the same moment, the court handed down the decision in Slaughter. It handed down the companion decision in the case of Lisa Cook, the Federal Reserve Board member. Words, they're hard. And what's so striking about the Cook ruling, in which a 5-4 majority held that President Trump couldn't fire Lisa Cook, at least yet, is that the majority opinion by John Roberts articulates an explanation for why the Federal Reserve is somehow different. And it makes a couple of contestable claims about history. It makes a couple of contestable claims about the role of the Fed, but actually it was Justice Kavanaugh who said the quiet part out loud in his concurrence. Why is the Fed different? It's the economy, stupid, right? Like the court doesn't want to wreck the economy. So Dylan, great, I'm pro not wrecking the economy, but you have to look at how these two things rise and fall together. How can you have a theory that the Constitution requires the president to have control over every single executive agency with any executive power except the Fed. Like, where is the constitutional interpretation that explains that lacuna?
Well, that's the argument for that these people are political triangulators and not just this unshifting principled beings that will never deviate from what they came into the court believing in their core. It seems that they do have their finger in the wind of political tides, or maybe they're thinking about their own bank accounts, whatever it may be. But they seem, very attuned to the realities of the day rather than just, sort of these platonic ideals.
And I want to say, like, I'm fine with that. And I think we should all be fine with that. The problem is that then you get the court turning around and saying, oh, but we have to decide this other case this way because it was thus in 1821. And
Yes.
right, there are two different problems there. First, the court ends up often being wrong about what was true in 1821. Turns out that lawyers are not especially good historians. But second, Dylan, it's the inconsistency. It's why are you pragmatic functionalists in the Federal Reserve case, but hyper-literal formalists, right, in the FTC case? That's the tension that I think is what animates the sharpest and harshest criticisms of the current Supreme Court.
Yeah, and fuels the argument that they just do what's best for their right wing friends and those in wealthy circles. Whether that's true or not, it feeds that fire. You mentioned that that some of their interpretations of centuries old statutes are wrong. I think Samuel Alito has recently been called out for just in multiple cases citing factually inaccurate evidence when authoring his opinions and or dissents.
Yeah, I mean, I think we've seen this a couple times, Dylan, where, and I want to be clear, like, Alito's not the only person who does this. There was an episode a couple years ago where Justice Jackson had a statistic that turned out to be wrong. Like, the justices make mistakes. That's fine. What I think is especially problematic in some of Justice Alito's behavior in particular is that there have been a number of cases this term where district courts, the trial courts that we empower to actually tell us what the facts are, right? The plaintiff says the facts are these, the defense says the facts are those. We have a judge whose job it is to say, actually, the facts are what I say they are. Those findings by district judges are not unreviewable by the Supreme Court, but they're supposed to come to the Supreme Court basically with a presumption of correctness, that you have to show the court that the district judge was clearly wrong and not just wrong to get the Supreme Court to overturn those findings. And yet, over and over this term, we saw the court, usually in Alito opinions, just running roughshod over district court factual findings. And just to take one example, Dylan, the Texas redistricting case is probably the most visible example. So that was about, Texas last summer trying to redraw their House maps to create 5 more safe Republican seats. And the way Texas did it, there was a lot of racial motivation. And there are statements in the record by Texas legislators. There's a letter from the Assistant Attorney General in charge of the Civil Rights Division at DOJ, Harmeet Dillon, that basically says that, even though this was also benefiting Republicans, part of what they were trying to do was undermine Black and Latino voters in Texas. This went to a trial court, a special 3-judge trial court for these kinds of cases. And you had a Trump-appointed district judge who made all of these extensive findings about how at least some of the line drawing and some of the map making was motivated by race, not party. And the case goes to the Supreme Court, and the Supreme Court writes, Dylan, 2 paragraphs to explain why this hundreds and hundreds of pages of district court fact-finding and opinions doesn't fly, right? And to allow Texas to draw their maps, not, Dylan, by explaining why the district judge was wrong, but just by pretending he didn't exist. And I think that's, separate from the justices making mistakes, which happens to everybody. I think it's the more nefarious stuff is taking district court fact findings and basically giving them no never mind when these cases get to the Supreme Court.
Has that escalated even among the current members, where even with the same members on the court in past years, has this degree of either contradicting or outright ignoring lower courts, has it ever been to this degree?
The degree point's the right one. I don't think so. I mean, it's hard, obviously, to sort, because some of this is subjective. When are you ignoring the lower court? When aren't you?
Yeah.
But it really is. I mean, two things have happened at the same time. And if I can just be a nerdy former math major for a second,
Yeah.
the first is the court's overall docket has shrunk, right? So, 30 years ago, 40 years ago, the justices were hearing 150 cases a term. Right. This term it was 55. That's a big drop, and we've been there for basically since COVID, where the court is hearing about a third of the cases it was hearing 40 years ago. So the denominator is a lot smaller, but Dylan, the numerator is bigger. Right. More of the cases the Supreme Court is hearing are big. More of them are politically charged and ideologically divisive. More of them are, national media stories, as opposed to hyper technical disputes that the lawyers love and nobody else cares about. And so I think it's, everything gets magnified when the denominator is smaller and the numerator is higher. And I think that's a lot of what's going on the fact finding piece of it. It's a lot of what's going on why it feels like the court is dividing ideologically so often. It really is a sort of magnifying effect of both a smaller docket and a larger concentration of these kinds of cases.
Is there a theory for why the docket has shrunk so much?
There are a couple, and the first thing to say is only the justices know when they're not talking. Justice Gorsuch tried to argue last summer at a conference that the docket is shrinking because overall case appeals are down. That turned out to be factually correct, but completely misleading, because he's including the categories of appeals that the court almost never takes, so-called informa pauperis appeals, where you have indigent litigants, whether prisoners or otherwise. If you look at what the Supreme Court calls paid cases, so these are like the law firm cert petitions or the government cert petitions, those have been flat over the last 20, 25 years. Why might the docket be down? So one is, ever since Justice Ginsburg died in September of 2020, the Democratic appointees can no longer grant certiorari, take up a case on their own. Right? Every single case that the Supreme Court hears is one that at least one Republican appointee has chosen to hear. And two, I think the justices are, they like these cases. They're interested in these cases. They would rather talk about whether transgender women can play on girls' sports teams than whether a super complicated question of bankruptcy law should have a different answer in California than it has in New York. The latter really used to be the bread and butter of the Supreme Court. When I was in law school, 25 years ago, maybe you got like 2 or 3 really big, high profile, politically divisive cases each term out of 85 or 90. Now it's like 20 to 25 out of 55. And that's a big shift. And I think the justices are principally, if not exclusively, responsible for that shift because they're picking their cases.
Yeah. And they another category that they seem to have weighed in on multiple times this term are cases regarding redistricting, as you mentioned you mentioned the Texas case, but there have been different redistricting attempts in different states. Some of these have either succeeded or failed on a state level. But is there consistency to what the Supreme Court has said about mid-cycle redistricting?
I mean, there's consistency. I like that. That's the word you use, because I wouldn't. I was waiting for is there coherence to what the court has said, and those are different.
Yes.
So I would say there are two different things that I would try to keep separate, although they've collapsed into each other this term. The first is the overall sort of law governing redistricting, and on the sort of the abstract law. The big Mama Jama ruling from this term, obviously, is Calais, the Louisiana redistricting case, where the court really took yet another hatchet to the Voting Rights Act by basically ratcheting up the standard that plaintiffs have to meet to show that a map dilutes the votes of minority voters in violation of federal law. Used to be, Dylan, right, for 40 years, that if you could show a map caused vote dilution, it didn't matter if that was on purpose or not. And now the Supreme Court has basically said, no, you got to show it's on purpose or else you're not allowed to respond to it. So that's Calais, and that is a huge shift and a narrowing of the Voting Rights Act. But then there's the immediacy of it. Since 2006, the Supreme Court has purported to follow something known as the Purcell principle, the idea that federal courts should stay out of election disputes while elections are basically ongoing. And so, obviously they can change the rules going forward, but we don't want the federal courts to be messing with elections while they're underway. Purcell went out the window this year. I mean, we talked about the Texas case. The court in Calais put its ruling into immediate effect, something it doesn't usually do, to make sure it could be used this cycle. The court wiped away a district court decision in Alabama so that Alabama could redraw this cycle. And so, there's two different problems. There's the substantive problem of how the court rejiggered the Voting Rights Act, and there's the procedural problem of how much in a hurry the justices certainly at least appeared to be to let these states take advantage of that new principle. And again, oh, what a coincidence. These states are all controlled by Republicans. And the map redrawing that the court allowed to happen immediately will only benefit Republicans. Like that may not be the intent, but man, it sure, looks like it's the effect.
But aren't we twisting ourselves into pretzels to say that may not have been the intent? I mean, in so many different cases, whether it's these voting rights cases or whether it's Trump's ability to function as a king, or whether it's even the idea that Trump could further function as a king by just doing a line item veto to the Constitution and 14th Amendment. I mean, the through line is what's good for Republicans and the current Republican president.
So I totally hear that, and I understand the sort of outward allure of that claim. There are contrary data points, and they're small, and I think they don't make up for all the problems, but they at least put some difficulty on the thesis that it's all Republicans, all Trump, all the time. So the court was asked after the Texas case to step in the California case, where California had passed this initiative in response to what Texas was doing, where California would add 5 more safe Democratic seats. And if the court really just didn't care at all about the law and was only in the bag for Republicans, it would have intervened in the California case. It would have blocked California's redistricting measure, which would have looked terrible given that it didn't block Texas's. But, if the theory is that Republicans, uber alles, that would have happened. So I think, that's a data point in the other direction. On the Trump stuff, right? Trump lost the tariffs case. He lost birthright citizenship. He lost the Illinois National Guard deployment case from December. So it's not that the court is reflexively ruling for Republicans and or Trump. It's just that they certainly seem to be giving the benefit of the doubt. Sort of whenever it's close, they go that way. And I think, that is not the same thing, but it's something worthy of criticism unto itself.
Yeah, and that is fair. Let me push it one more though. That it's true that the court's overall decisions, do have that degree of nuance. What about two people in particular, which would be Clarence Thomas and Samuel Alito? They seem to reflexively vote in the Republicans' direction, unless I'm mistaken, unless they were part of allowing California, or maybe California. If you can fill me in there. Those two seem to just be full-on partisan.
I mean, I think their voting behavior is more troubling than the other 4 Republican appointees. And, but just as a data point, at least publicly, they did not dissent in the California case. Mm-hmm. Maybe they dissented behind the scenes. One of the fun things about the emergency docket is we don't always know. But right. Listen, I am not here to suggest that there isn't a lot of partisan behavior happening on the court. I just think that we should be nuanced and careful to at least articulate the principles on which the court claims to be relying, and then explain why those principles aren't being followed consistently. And then if the principles aren't driving the bus, what is? Of course, that's where I think the appearance, at least, is justices voting on their preferences. And I'll just say, I think the Democratic appointees do that too sometimes. We just don't notice as often because they lose so much.
True. We've hit sort of the major cases that came down this term. Are there any that you'd like to highlight that we have not mentioned?
I mean, one of the problems of talking about the Supreme Court when the numerator is so high is that there's too much.
Yeah.
So we haven't talked about transgender discrimination. We haven't talked about the campaign finance case, which also overruled an old precedent, for reasons. I think it would probably not be worth it to go into too much detail on those, except to say one data point that I think is quite revealing of where we are. So last term, when the court was, just as much of a lightning rod and handed down all bunch of controversial decisions, there were a total of 6 rulings out of 56 in which the lineup was the 6 Republican appointees in the majority and the 3 Democrats in dissent. This term, that number was 17. And, that is, I think, a powerful sign of how much more ideological even this term was, right, compared to terms in recent years where we've thought the court was just as controversial and just as much of a lightning rod.
Well, and that trend seems unsustainable, which would sort of lead us into a second topic, which you've agreed to come back and join us, which would be about how do we improve this situation? What do we, the people, have as realistic options to improve an increasingly maddening Supreme Court? So we will be having you back for another episode to join us in that. And Steve Vladek, thank you so much for talking us through this whirlwind of a Supreme Court term, especially a final week of the Supreme Court term. And we look forward to having you back on Personality Crisis.
Thanks so much for having me.